A very good evening, dear friends. Hope you're doing fine. I'll just wait for a minute or so I can start my class. Today we'll be dealing with the amendment of constitutions, the most important provisions pertaining to that. So meanwhile, kindly ensure that you follow me on Unacademy, right? Please follow and subscribe. My name is Cyril Jacob, your educator at Unacademy. You can use my referral code to subscribe so you will get a 10% discount. Use my referral code only, you will get the discount. So please make sure use the referral code, which is Cyril Thomas Jacob. CYRIL THOMAS JACOB. You have a lot of benefits for plus. I'll get to that in the later half of the class. Meanwhile, I'll be discussing the importance of amendment to the Constitution, right? Important cases and provisions. So firstly, moving on, one more thing I would like to stress on is that anybody, if you have doubts, kindly put it in the chat box. So I'll be clearing it for you, right? I'm signed in through my phone. So if you have any doubts, please. Put it in the comment box so I can clear it for you. Right. So now first slide we'll get into the need or importance of amendments. Right. Need or importance of amendments. So what is the need for amendments in India? When we talk about amendments, we are dealing with constitutional amendments. So why should there be constitutional amendments? So there are various factors. Apart from this slide, there will be a number of factors, right? Within a time span of 1 hour or 2 hour or one day, we cannot discuss this. In fact, our constitution is over 50 to 60 years old, right? It came into being on 26 January 1950. So many advancements, we have over 100 constitutional amendments, right? Today, India has over 100 constitutional amendments. So what are the prime factors to be considered? Why is there a need? We look first to meet the requirements or needs and aspirations of the citizens of the nation. Now, Constitution is the supreme law of the land, and it has fundamental rights. It has directive principles of state policy. It has the duties and rights of president, the executive. It lays down the code for following for the legislature, right? The three branches of the government, the executive, legislature, and the judiciary, they are very important, and it lays down their function. Moreover, it safeguards the fundamental rights of the citizens of the nation. Second reason, there are various shortcomings or provisions of law that cannot be said to be constitutional. In that case, they will be removed or withdrawn after proper consideration. Now, who does the consideration? It is the judiciary. In most cases, the Supreme Court. Because the duty of the court is to uphold the law and safeguard the fundamental rights of the citizens. So protect the fundamental rights at all costs. Now, third one, there is a constant evolution of laws. So, law is something that is a very continuous process. Every day, there is some kind of new law or amendment to the existing legislation. Then, to safeguard the fundamental right of the citizens, which I have already highlighted in the first one. Moreover, to enhance the quality of life of citizens, right to life and liberty, that is guaranteed as per Article 21 of the Indian Constitution. Then, to protect the rights of marginalized communities, to protect against exploitation. So, right against exploitation, that is Articles 23 and 24. Then, to ensure branches of the government, that is the executive, legislature, and judiciary, do not abuse the power. So, the three branches, they are accountable. Right, to the judiciary. The three branches, they are to be held accountable to the citizens of the country as a whole. So, if you look at it from one angle, judiciary is independent from the executive and the legislature. So, both the executive and the legislature should be able to be accountable to the judiciary, because nobody is above the law. Okay, the law is supreme and constitution is the supreme law of the land. Everyone has to adhere to the provisions of the constitution. Now, there have been instances, dear friends, where the constitution has considered amendment whether it is really necessary or not. There has been situations during the emergency time in India in the year 1975 when there was a famous election case which was a former prime minister, involving a former prime minister and political leader, a former prime minister and political leader Indira Gandhi, and another opposition political leader Raj Naren. Now, things turned a bit ugly that time, but still we need to, the court always upheld the law and uh, expressed their desire to protect the doctrine of the basic structure of the constitution, which is the fundamental rights. So, the fundamental rights cannot be amended, it cannot be altered, it cannot be destroyed. Destroying the fundamental rights, there is no authority which has the power, no authority in India can sabotage the fundamental rights. And time and again, the Supreme Court has been providing the judgments favoring the fundamental rights of the citizens. Right? Kindly let me know if you have any doubts, dear friends. Moving on. Amendment of the Constitution. Part 20 of the Indian Constitution has only one part. Okay, article number 368. Now this article deals with the amendment of the Constitution, and based on this particular article 368, the Parliament may add, amend or repeal. Amend in the sense it may modify or alter any constitutional provision. What is the meaning of repeal? It may take away, or the apt word is withdraw. So one fine exception pertaining to amendment of the Constitution is later on in Keshavananda Bharati case versus State of Kerala. So this is the landmark case where fundamental rights importance was highlighted by the Supreme Court of India. And Keshavananda Bharati case was encouraged by senior lawyer, most of you should have heard about his name, Palkiwala, Nanibhai Palkiwala, to file a petition before the Honorable Supreme Court in order to ensure that the fundamental rights of the citizens in Kerala or in India, considering the doctrine of fundamental rights, should be safeguarded at all times. Right? In this particular case, right, it is a 13 bench judge. So all those 13 judges, they studied the case, analyzed it, and gave the most suitable judgment. And till today, there have been over thousands of cases where this particular judgment of this case has been cited. So this case has been reported in the All India Reporter in the year 1973 by the Supreme Court, precisely at page 1461 or 1461. So the major ruling in the Keshavananda Bharati case was that the Supreme Court ruled or held that the Parliament cannot, I repeat, it cannot amend those provisions which constitute the basic structure of the Constitution. What was held or what was reiterated by the Justice Sikri, right? Justice Sikri, he held that the Constitution of India is secular in nature, it's democratic in nature, it's sovereign in nature, right? So that basic structure of the Constitution. Now India is a democratic, socialist, secular, sovereign, socialist, secular republic, right? So the Supreme Court brought out a judgment that although the Parliament's duties are to make laws, to amend laws, to alter or to repeal any provision of the Constitution, they cannot and should not be allowed to amend those provisions which fall under the category of the fundamental rights, that is part 3 of the Indian Constitution. When we talk about fundamental right, it forms the life, blood, heart, soul, everything of the Constitution. Today, if at all we are able to walk around in freedom, we have right to freedom and speech, freedom of speech, of expression, Article 19. We have right to equality. Articles 14 to 18 deals with right to equality. Then we have Article 21, right to life and liberty. So there is the golden triangle which I have highlighted in many of my classes, right? Article 14, Article 19, Article 21. Apart from this, so many factors have been definitely added, but it has not been, the provision has never been amended to such an extent that it will affect the fundamental rights of the citizens. The Supreme Constitution is a sovereign law of the land, and that should be safeguarded. It should not be a situation where the Parliament, which is the legislature of India, should be given a chance. It should not be given a chance to amend any provision which will constitute the basic structure of the fundamental right of the Indian Constitution. Right? Any doubts, dear friends? Please put it in the comments so I can see your doubts. Hope you are following. Right? Kindly put in a comment if you are following. I'm signed in through my phone, so I can reply to your comments. Right? Now moving on. Now this particular case, Golaknath versus State of Punjab. So this happened before the Keshavananda Bharati case. So the Keshavananda Bharati case, in a way, it overruled this particular Golaknath versus State of Punjab case law. Thank you, Priyanka. I'm really glad you're following, right? Make sure you follow me on Unacademy also, so you'll have access to all my content. There are a lot of videos, there are a lot of content where you can access, right? So the Supreme Court held that the Parliament has no right to abridge or abrogate the fundamental rights granted by the Constitution through an amendment. So fundamental rights are the most essential rights for a human being. How can a man live without freedom? If a man is being bound in chains, he is forced to be kept in a particular place. Okay? If his own shadow is a threat to his life, that is when freedom is curtailed. Okay? That's a problem. Constitution of India is supreme, and the apex court, which is the Supreme Court, applied that fundamental rights are supreme. They applied this in a series of cases. In a series of cases, we have the bank nationalization case. We have the Privy Purse case. Now, what is the Privy Purse case? If you know that there was a Privy Purse system in olden India. When I talk about olden India, I'm not talking about Mughal Empire. No, I'm talking about British India, to be specific. In British India, there was various states that were called royal states. For example, Mysore. Till today, you have the royal Mysore family, the Wadiyar dynasty. Then they had Travancore. Sorry about the pen, just going haywire. Then you have so many places in Rajasthan, Jaipur, right? Royal families were staying there. Today also, if you go to places, you will see the Martanda Varma. There is the Varma family, who was the erstwhile king in Kerala. His descendants are there. In Trivandrum, the place where I am from. In Mysore, if you go, you will see the latest scion, the Wadiyar dynasty, who just recently had a child. Then if you go to Jaipur, you will see princesses, right? So many. So earlier, there exists the system of Privy Purse. This was introduced in the form of a British kind of regime, in the British regime. So under what is this Privy case, I'm going to explain to you. In the year 1971, the Privy Purse system was abolished. It was abolished. The reason why it is abolished, because Privy Purse is like a treasury. It's like a treasury, okay, where the royal families should be given money annually, okay, annually. That is, every year they'll be getting a particular amount from their subjects. So the government of India was annually giving them over 20 lakh rupees. Some families were getting 40, 50, 60 lakhs. I'm talking not about the millennium era. I'm talking about 1950s and 40s and all. If you were getting 20 lakh Indian rupees, today it will be worth hundreds of crores. So during the 1971, the Indian government took a serious stand to abolish the Privy Purse system. And in this Privy Purse system also, another what is applied is that Golaknath versus State of Punjab, that fundamental rights are supreme, which the Supreme Court held. Okay, fundamental rights are the most important rights, and it should not be violated, abridged, or abrogated. Okay, Parliament has no right to do that. That was again reiterated or repeated by the Supreme Court in the Privy Purse case in the year 1971. Now, bank nationalization. Earlier, a lot of banks came under the control of the government. Okay, a series of banks. Privatization. Private banks came under the public, became public, that became nationalized. So, there were certain cases that were put before the Honorable Supreme Court. And the same principle which is held in Golaknath was the State of Punjab, which is reported in the All India Report of 1967 by the Supreme Court Review. Okay, it was held clearly that's why SCR, Supreme Court Reporter, right? It was held that fundamental rights cannot be violated or cannot be abridged or abrogated by the Parliament, which is the legislature of the nation. So one more factor was highlighted in the Golaknath versus State of Punjab case. The court here challenged the right of the Parliament to curtail the fundamental right. Okay, so there is an open challenge that is issued to the Parliament. It is like a warning. It was a warning. Do not dare to violate that. The constitutional provisions enlisted in the fundamental rights, part 3 of the Constitution. Right, friends? Hope you are following. So, what did the Golaknath, what are the amendments that came with the Golaknath case? A series of amendments. If at all in India there was the 24th, 25th, 26th Amendment Act, okay, the Constitutional Amendment Act, if at all the 24th, 25th, 26th Constitutional Amendment came into place thanks to the Golaknath versus State of Punjab. However, in spite of all these being said, Keshavananda Bharati case, it has been critically analyzed. The Golaknath versus State of Punjab case has been critically analyzed. So many developments are happening till today. Okay. So one must realize that the importance of Golaknath versus State of Punjab, but this particular Golaknath versus State of Punjab occurred in the year 1967. The judgment is given, whereas Keshavananda Bharati versus State of Kerala, please look at the slide, was reported in the year 1973 by the Supreme Court, the All India Reporter. Dear friends, any doubts? Hope you are following. Kindly put in a comment if you are clear. If you have any doubts, let me know. I also discussed in this particular slide, the Golaknath slide, right? I discussed two other cases, bank nationalization case and the Privy Purse case, which is extremely important. As a lawyer, you should be able to be analyzing these cases very systematically. Right? Moving on. The election case, right? The election case, which is so followed, which is one of the most important cases in the history of Indian Constitution. One of the cases that clearly stands out, because it is the first time in the history of India where a Prime Minister was summoned to the Allahabad High Court during the election timings. Indira Gandhi versus Raj Narain, the matter reached the Supreme Court, and Indira Nehru Gandhi versus Raj Naren. They were both politicians who were at two different ends. One was in two both extreme ends, right? They were political leaders. Mind you, Indira Gandhi was the prime minister at that time. And this case led to so many factors, right? This was one case that led to emergency. It's called the emergency case also, national emergency case. So please note down, this was reported in the All India Reporter by the Supreme Court cases, right? In the year 1975, precisely you will find it in the Supreme Court cases at page 2299 or 2299, right? 2299, that's the page number. So what was the importance of this particular case? Okay, now we have Article 329A of the Indian Constitution. A particular clause was added that was troubling certain individuals. Now, when can the Supreme Court strike down a particular provision of the Constitution? When can it do that? In countries like America and all, Supreme Court, if it finds any provision of the law which is unconstitutional, it will be declared as void or it will be declared as invalid. So when it comes to Indian landmark cases also, the Supreme Court has that power. In this case, the Supreme Court struck down clause 4, that is Article 329A, clause 4 of the Indian Constitution was absolutely considered as void because it was considered to destroy the basic structure doctrine of the Constitution. And what is the basic structure doctrine of the Constitution? That we are a democratic country, we are a republic country, we are a secular country, we have our freedom. Okay, the law should be respected. So there was one senior judge, Justice Y.V. Chandrachud listed 4 basic features in which he considered that should never be amended. So what are those features that cannot be amended? It is listed as A, B, C, D. Let us look at point A. Sovereign democratic republic status. Sovereign means supreme. Democracy. India is the largest democratic country in the world. That is, people's opinion are respected. If you go as per Abraham Lincoln's definition of democracy, he said democracy is a system of administration, a system of government where it is of the people, by the people, and for the people. Who is this people? They refer to citizens of that respective country. Republic status means it's a non-monarch. Republic is not equal to monarch. Monarch means there's a king or a queen which governs or rules the country. What they say becomes becomes law also. Right? So sovereign democratic republic status can never be or should not be amended at all. You can also say they are unamendable. Unamendable. So point B, equality of status. Irrespective of caste, creed, sex, religion. Okay. So gender bias should not be there. Caste bias should not be there. Okay. So many things should be considered. Equality of status and opportunity. This is guaranteed in which part of the Constitution? You should know that this is guaranteed in the preamble of the Constitution. You should look at the preamble. preamble of the Constitution, the introductory note, the most important introductory note. We, the people of India, have resolved to constitute India into a sovereign, socialistic, secular, democratic republic, and to provide us with the equality, justice, fraternity, right? Justice, when you talk about justice, economic, political, social, okay, opportunities, equality, status and opportunities. Then secularism, that is tolerating every religion in India. Every religion is encouraged, it should be tolerated. Moreover, there should be freedom to practice any religion, practice and profess any religion whatsoever. Secularism, that is, you be either without no religion or you focus on religion. That is totally the free will of the people. Freedom. Now, government of laws and not of men. That should what a system of administration should be. That is what a system of administration should be, as per Justice Y.V. Chandrachud. So that is basically what contributes to the most essential concept of thought called the school of thought called the rule of law. So if we talk about rule of law, just remember A.V. Dicey. He was a senior judge and his thumb rules. Okay, please refer to that. I believe I have taken a class on that. If you do not know, you should refer to that. A.V. Dicey's rule of law theory. The limb rule or the thumb rule, right? Dear friends, any doubts? This is the election case. Once again, yes, so since I believe everything is clear, now we'll go to the Minerva Mills case. Dear friends, I don't know, I have this excitement when I talk about these cases because as a lawyer, these are the cases that we, study so much in our colleges, and even when we go out of college, this has importance. See, these are cases. Okay, my classes are in English, though I got a comment in English. I'll respond to you. The response sheet kab tak aayegi. Okay, so you will have to follow the net exam website, official website, nta.nic.in, right? They will be updating you that. Okay. Meanwhile, just for the information, I am handling on my Unacademy profile on the portal. Okay, for subscribers, the benefit is that you will be having access to all my videos, and this month I'm handling strategies on how to crack the law paper, strategies on question papers, strategies on previous year question papers, and how to solve even paper 1. That is what is unique this month. So I'll be dealing with teaching aptitude, communication, reasoning, syllogisms, all the basics, Venn diagrams, everything I'll be training on the Unacademy portal. So you can follow me, follow Cyril Jacob, and make sure you subscribe using my referral code, which I had given in the first slide. For those of you who have joined in late, please make sure you watch this video from the beginning onwards, so you'll be having access to that referral code, right? So this is the case once again that I'm really enthusiastic about, because if you know these few cases which I'm discussing today, It should be at the tip of your fingers. You should be able to know. Even if somebody wakes you up from your sleep and asks you which year was the Keshavananda Bharati case, you should be able to tell 1973. The Indira Gandhi versus Rajnaran case, just remember the year of emergency, 1975. You should be able to follow a systematic pattern. When I say systematic pattern, you should remember which case came after which case. For that, you need to maintain a book, a big challenge book, without which you will not be able to, how am I able to remember these cases? To be honest, I take down notes. Okay. So Priyanka, yes, I'm taking special classes also in December. So make sure you follow the my channel, because my channel, if you're not following, you will not get any updates which is coming up on my feeds, right? So let us get to this Minerva Mills case, and then if you have any doubts, dear friends, we'll take it up from there, right? Right. So all of you, my humble request is, um, follow me, so you will get all the updates as to when my classes are. Okay, normally my sessions are in the evening, but few classes this month are in the morning also, so morning and evening, so there is a combination. So please be able to take time out and study, or view the recordings. So Minerva Mills versus Union of India, reported in the Supreme Court cases in the year 1980, precisely at paragraph 3 and page 625. This is the year. See, when you learn the citation, you should know, please refer citation. How do you do that? Refer and learn. Write down. Okay, refer and learn. Okay, so in this case, the validity of the 42nd Amendment Act was challenged on the ground that they are destructive of the basic structure, like I mentioned in the previous case laws as well. Anything that is destroying, abrogating, abridging the basic structure doctrine of the Constitution should be unconstitutional, and the Supreme Court will, I repeat, it will, it should, it must, and it will, once again I am repeating, it will unanimously. What is this word unanimously? In majority. And you know what was the majority in striking down that Article 368 clause 4 and 5 inserted in the 42nd Amendment? It is 4:1 ratio. That is, there were 5 judges, dear friends. There were 5 judges for the Minerva Mills case. And would you like to know who the lawyers are? It was Mr. Palkiwala. And you will be really thrilled to know who his assistant was. His assistant was Harish Salve, former Solicitor General of India. One of the finest lawyers in India. Okay, if you do not know who Harish Salve is, please YouTube him. Watch his lectures. Okay, he is one of the most well-to-do, well-spoken lawyers. He represented India even in the International Court of Justice. And he's one of the lawyers, Harish Salve. He trained under Nanibai Palkiwala, who's no more. Okay, he trained under Nanibai Palkiwala, and he is one of the only lawyers who is the Queen's Counsel. Now, what is the Queen's Counsel? Queen's Counsel is, he's the official lawyer for the Queen of England. That kind of, Queen's special lawyers are there, right? So he is in that particular board, which is a big thing for India. You will not find many Indian lawyers on that particular panel, right? So it's a big thing for India. So many things are there to know. Okay, and this Minerva Mills versus Union of India case, the Supreme Court, what is the importance of the case is that Article 368 clauses 4 and 5 of that particular 368 was struck down, which was inserted in the 42nd Amendment. The reason why this was done is because it destroyed the essential feature of the basic structure of the Indian Constitution. So to be said, never one should mess with the basic structure doctrine. Nobody has that right. So it is ruled by the Supreme Court that a limited amending power itself is a basic feature. So there are limitations. that should be kept in mind. So we discussed around 5 to 7 cases. Now what are those cases? Once again I'll repeat. Firstly, Keshavananda Bharati was a state of Kerala case, right? Then we had the Golaknath versus State of Punjab case. Then we had the bank nationalization case, Privy Purse case, right? Election case or emergency case, Indira Gandhi versus Raj Narain. Then we had the Minerva Mills case. Okay. So are you crystal clear, dear friends, with these cases, the basic purpose? Because today we are talking about the important cases pertaining to or with regard to the amendment of the Indian Constitution. So just remember this 5 to 7 cases which we handled today. Okay, is it clear? Please put in a response. If it is not clear, I will try to clarify and offer to clear your doubts. Now, yes, okay, limited amending power. Priyanka, I saw your question, right, Priyanka Arun? So, what is limited amending power? It means that the constitution, there is no hard and fast rule that the constitution cannot be amended. No, 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 no. You amend the constitution, but don't mess with the basic structure of the constitution. Now, as I mentioned earlier, okay, I believe there is 103 constitutional amendments. Okay, there are around 103 constitutional amendments. Do you think anything has altered the fundamental rights? Do you think anything was allowed to destroy the fundamental rights? Absolutely not. If any amendment of the constitution, which is who amends the constitution, who has the power? It is the parliament. If at all parliament amends the constitution in such a way that it violates, abridges or abrogates the fundamental rights of the citizens of India, then that particular provision or amendment will be struck down by the Supreme Court. Okay, so it was ruled in the Minerva Mills case that a limited amending power itself is a basic feature of the Constitution. It is a basic feature of the Indian Constitution. You can amend certain things, but never destroy the essential feature of the basic structure. The basic structure of the Indian Constitution is kind of sacred. Do not touch it. So, okay, that should not be a multiple amendment. Which, yes, the basic feature should not be destroyed. All you need to know, one thing is, nothing much to be complicated about. Just that now I believe you got it. So that's good. Okay, so yes, the basic feature of the Indian Constitution should not be violated. That's the word. Infringed, violated, breached. All these words you can use. So is it clear? Now what is the procedure then? Friends, you should be curious. You should be asking yourself also when you study, what is the procedure? What is the procedure to amend the Indian Constitution? Don't you want to know? We discussed these many cases, but if we do not know how to proceed to amend the Constitution, then we are lagging out on something. So this is the procedure which I am highlighting for you in the next 10 to 15 minutes. Now, many of the citizens, they are not aware on how a particular constitutional amendment is made. It doesn't happen overnight. It's not like members of parliament, they come together in a group and say, Bhaiya, ye chahiye, Bhaiya, wo chahiye. Hey, look at this, look at that. Come on, see mine, see yours. No, 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 no. It will not be like that at all. There is something called reading of a proposal, which is a bill, and the bill to amend the constitution can be introduced in any house of the parliament, but not in the state legislature. Parliament is the national legislature, central legislature. So which are the two houses? It can be introduced in the Rajya Sabha, which is the upper house, or the Lok Sabha, which is the lower house. Any of the houses it can be introduced. That is the first point. The ordinance making powers of the president. Do you know that the president has the power to make assent? When he gives an assent, okay, the president has to put his signature on the bill. Then only it will become an enactment, or then only it will become an amendment. However, enactment is true, okay, but ordinance making powers of the president cannot be used to amend the constitution. He cannot use his powers to such an extent just for the sake of amending the constitution. No. But ordinance making powers of president, when we talk about, even governor has ordinance making powers. He puts his signature on state laws. Who is governor appointed by? He is appointed by the President of India. All right. The governor is appointed by the President of India. Governor and President both are executives. Okay. They have ordinance making power, but it cannot be used to amend the Constitution of India. Third one. Any amendment proposal or any amendment bill can be introduced both as a government bill or as a private member bill. Who are private members? They are independent candidates. Have you heard about independent MPs? You know, can you anyone tell me who is an independent MP? I would appreciate that example, but I'll just quickly quote it to you. Sachin Tendulkar. He does not belong to any political party. He is an independent candidate from Mumbai constituency, right? So Sachin Tendulkar has the power with him as an MP to introduce a private member bill. Then the next stage is that the prior recommendation of the president is not needed. Okay, you do not need the President of India to recommend in order to introduce an amendment bill. Without that, it's possible to go ahead. However, please note this point: bills are not, I repeat, are not treated as money or financial instrument. It's not bill of lading or bill of exchange. Okay, it is a proposal that is made in the parliament. Which is the legislature. And finally, if you look at this last point here in this slide, a constitutional amendment bill was passed in both the houses separately. So there should be an absolute majority and a special majority. What is absolute majority? More than 50% of the strength. And what is special majority? More than 2/3 of the voting power. When it is combined, it will be passed as an amendment of the constitution. So a lot of groundwork goes into this. Dear friends, are you following? Is it crystal clear? Please put in a comment. I need response so that I can also proceed. Thank you. So now look at the alternative factors that are on the side. What if there is a conflict of interests? What if there is a disagreement between the two houses of the parliament on a particular constitution amendment bill? Okay, then there is no provision to resolve the deadlock. That is, they cannot sit together. That is, you can never combine Rajya and Lok Sabha, dear friends. I'm really glad that you are liking my explanation, friends, and this keeps me motivated, and I'm just doing what I have to do. This is my duty, but It is really comments and feedback do really keep me motivated. Thank you a lot, Priyanka. Thanks on that comment. Uh, Now, so what you need to understand, friends, is that if there is a disagreement between the two houses, there is no provision in the world. Nobody can help that. You cannot keep both the all the members together. 1,000 members there are. You can't put them together and say, "Come sit together. We'll sit and solve the problem." No, 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 no. It doesn't happen that way. Okay. So just that is just a point to just note down for your reference. Okay. So joint sitting will not be allowed. Next point. Simple majority is not deemed to be a constitutional amendment. So they should be absolute plus special. If this is not there, it will be simple majority. Okay, you cannot pass an amendment act. What is the next point here? Please look at the slide. If a bill seeks to amend the federal provisions of the constitution, it must also be ratified by the legislatures of half of the states. Now, how many number of states in India? There are today, Jammu and Kashmir is not a state, so it's a union territory. So 28 by 2, that is 14. 14 states at least should, what is the meaning of ratification? Implement. That particular amendment should be implemented by the legislatures, that is the state legislatures of half the states by a simple majority. Then that amendment you can go ahead and amend the federal provisions of the constitution. Please note the final point here. Once the bill is passed in both the houses, it is sent to the president for his approval. So under his seal and signature, there can be a approval. Okay, so he has to sign and put his seal, the President of India. Is it clear, dear friends? So we discussed the important amendments. I'll just go into. After that, we'll come to an end of this, right? Important amendments. Just 2 more slides. So 1956, I've given you in a very systematic hierarchical pattern, that is एक के बाद एक आता है, एक के बाद दो आता है, तीन आता है, चार आता है, like that 1 2 3 4, not 1 7 6 4, no. 1956, 1960, 61, 62, like that I've given. So it will be easier for you to remember, and all my classes I stress on hierarchical pattern. It is easy to remember. Okay, you take any competitive exam in India today, okay, from IAS exam to the state level or SBI clerk exam also, you will be having to learn on a hierarchical pattern. It's easy to remember that way, right? So in 1956, we had the 7th Amendment. States were reorganized based on linguistic basis and union territories were introduced. Okay, 7th Amendment, please note down. 1960, 9th Amendment. The Indian territory was adjusted due to an agreement with the nation of Pakistan, 1960. The 10th Amendment came about in the year 1961, where Dadra, Nagar and Haveli, these 3 areas were acquired from Portugal, and they are a union territory today in India. Dadra, Nagar and Haveli are included in the Indian Union as a UT. What is UT? Union Territory. In 1961, again in the same year, 12th Amendment came, where Goa, Daman and Diu were again acquired from Portugal. So the Portuguese played a big role in handing over them to India as the Union Territory. 1962, the 13th Amendment, Nagaland was formed as a state with special protection under Article 371A of the Indian Constitution. In the same year, 14th Amendment came into place, and Pondicherry was acquired after a Transfer by France. Pondicherry was a French colony. I hope you will be knowing that. The year 1967, 21st Amendment, Sindhi. It's a language included in the 8th schedule. Again, another 26th Amendment, 1971. The Privy Purse system was abolished. Please refer to my earlier case. The year 1975, 36th Amendment, Sikkim was included as an Indian state. 1976, 42nd Amendment, fundamental duties prescribed, India became a socialistic secular republic. It is called a mini constitution. 42nd Amendment is called a mini constitution because it is detailed. Constitution of India is the largest constitution in the world, especially the largest democratic country we are. 1978, 44th Amendment, right to property was deleted from the list of fundamental rights. So, right to property is no longer a fundamental right. The year 1985, 52nd Amendment, defection to another party. That is, if you are withdrawing from one party to another after election, it is illegal. The year 1989, 61st Amendment, voting age was earlier 21 years. It was now reduced to just 18. 1992, dear friends, hope you are able to keep up with my pace, right? Since it's a 1 hour session, I'm just slightly going a bit pacey, but I believe since everything is on the screen, you can understand. A few languages were added in the 8th schedule in 1992 through the 71st Amendment, namely Konkani, Manipuri and Nepali. By the 73rd Amendment in the year 1993, Panchayat Raj system was introduced and added to the 9th schedule of the Indian Constitution. Panchayat Raj is a local government, right? And again, in the same year, through the 74th Amendment, municipalities were introduced. They are also local government. In the year millennium 2002, 86th Amendment made free and compulsory education to children between 6 to 14 years. In the next year, 2003, 92nd Amendment, Bodo, Dogri, Shantali, Maithili were added to the list of recognized languages. 2012, 97th Amendment, introduction of 9B in the Constitution regarding cooperative societies. Right? And most recent amendments, 2016, 101st Amendment, introduction of GST, Goods and Services Tax. 2018, 102nd Amendment, establishment of the National Commission for Backward Classes, the NCBC. And of course, this year we had the 103rd Amendment, which is the economic weaker sections reservation for them, economically weaker section. Please note, you will have this maybe as a question in your net exam next year. 42nd Amendment is the most comprehensive one and is referred to as a mini constitution. The 52nd Amendment is the only one which is unanimously, that is majority way, it is adopted by the Parliament. Friends, please make sure you follow and subscribe. Alright, please let me know if you have any doubts. How you need to subscribe is use my referral code Cyril Thomas Jacob, CYRIL THOMAS. Follow me. Look out for Cyril Jacob on Educator platform, Unacademy, right? And you have weekly quizzes. From my side, you have monthly mega quiz. Then moreover, you'll be having doubt clearing session. My doubt clearing sessions are 2 hours. So you can ask me all the doubts regarding the subjects and I will clear it for you. Okay, that's the plus point of my classes. So ensure you subscribe to Plus Unacademy and follow me. How is the class, friends? Please put it's a live chat. Please make sure you give the positive comment so that even others can see it if you like the class. And give me a hat or something, that is, you can dedicate hats in the platform, like something like saying hats off. So thank you. so much, dear friends, all those who have joined in, Priyanka, right, Udit. So thank you so many for joining in, and hope you all will be following me on Unacademy platform for the you'll never miss the update, right? So stay tuned and stay safe. Have a good night. God bless. Cyril Jacob signing off. Good night, friends.